everyone, this is Tyla from the F.W. de Klerk Foundation, and you're listening to the Constitution at Work podcast, the series for people interested in constitutional matters and transformation in South Africa. Today, we are talking about the importance of free speech for a functioning democracy and to enable Chapter 9 institutions and whistleblowers to hold government accountable. Today with us are Advocate Paul Hoffman, Director of Accountability Now, and Cynthia Stimpel, Executive Director of Whistleblower House. Thank you to each of you for joining us. Now, just to provide some context, the Foundation has been monitoring the movement of the hate speech bill before Parliament. We believe this bill poses a real threat to the right to freedom of expression guaranteed by Section 16 of the Constitution and would stifle free debate on a wide range of topics, which would have very serious consequences for our constitutional democracy. Cynthia, I'm going to start with you. What role does freedom of expression play in allowing whistleblowers to expose corruption and maladministration? And what are some noteworthy examples of this?
Thank you for the question, Tyla. If you recall, when free speech first became an issue was through whistleblowers driving free speech in the earlier years, having the freedom of expression, having to speak out against atrocities, having to find solutions where government was either too authoritarian in human rights issues. So where does it fall then under the whistleblower protection and whistleblowers being able to speak freely? Whistleblowers play a huge role, as Judge Zondo said in his report, that they are the last defenders against any atrocities or against corruption. So with whistleblowers being freely able to speak, they're able to raise issues of concern, firstly, in organizations that they're working in, where they do identify fraud or corruption or going against legal matters within that organization, for instance, environmental issues. Another area where whistleblowers play a huge role is being able to highlight fundamental issues that have happened throughout organizations, be it globally, be it in South Africa, which we've seen through either the Gupta issues, and that was the Gupta leaks, through Wikipedia as in the global areas, through Snowden leaking out information regarding the CIA and NASA having in fact, following and being using data, personal data for their use. So whistleblowers in South Africa, and those are the pronounced ones I'd like to mention, is the current cases we have. For instance, Ms. Babita Deokaran was a financial accountant within the Department of Health. And in her role and just doing her duties, her fiduciary duties, is that she had identified there was money going to certain organizations. There was no correct evidence and documents to say that these were providing services to the organization, and the amounts were below the threshold of 500,000, which doesn't require certain approval. And when she identified that, at that time, she raised it with a senior, and through that process, she was assassinated for doing her job. So another key whistleblower is Martha Ngoya, who identified the Shivambo rail deal, whereby they were going to pay over 45 million to an organization that wasn't fully equipped for providing the correct train systems to South Africa, to Transnet, and PRASA being the passenger rail organization. And her having spoken out has suffered the consequences and lost a job. Yet, in the recent 2 years, each of her cases which have come to the court, she won each of her cases. And yet, the board of the organization, the executive of PRASA, are still not able to give her back her job and are still victimizing her. So this is the knock-on effect of whistleblowers, and this is the importance of why whistleblowers need the freedom of speech, why whistleblowers need to be supported when they are speaking out and not vilified and made to be this impimpi or a snitch and then treated as such, that the information has no forbearance on the organization and on the country. And just using her case again, is that when you look back, we do not have the train system running as effectively as it should have. We have seen the demise of the network system, the rail network system. We've seen that the normal citizens aren't able to just get to their positions and places of work where they're supposed to be. So that is the true knock-on effect of when whistleblowers are unable to speak truth to power. Thank you.
Thank you, Cynthia. Paul, I'm going to ask the same question of you. What is the importance of freedom of expression for Chapter 9 institutions to be able to do their work, and what are some noteworthy examples?
Thank you, Tyla. And I think what the starting point really dovetails nicely with what Cynthia has just said, because there is a symbiotic relationship between the work of the Chapter 9 institutions and the willingness of whistleblowers to exercise their free speech and come forward and make reports or complaints to the 6 Chapter 9 institutions that exist in South Africa. We must all remember that the purpose of having Chapter 9 institutions, almost like a fourth sphere of government, fourth leg on the pot, if you like, is to strengthen and support constitutional democracy. And certainly as far as the major institutions are concerned, the Auditor General, the Public Protector, and the South African Human Rights Commission, it is important to know that the public should feel safe to approach what is a constitutionally guaranteed independent institution to make their concerns known. The Constitution itself says that other governmental institutions are obliged to support the effectiveness of Chapter 9 institutions and their ability to operate without fear, favor, or prejudice is also guaranteed to them in the Constitution. So without the flow of information that those willing to exercise the right to free speech will indulge themselves in, if they are prepared to stand up and be counted and to draw the attention of, let's say, for example, the Human Rights Commission to threats to or infringements of their human rights, or in the case, more importantly, of the Public Protector, to anything that amounts to prejudicial conduct in the affairs of state or in the public administration, we will not get activity. In fact, a lot of the work that the Human Rights Commission is obliged to do comes from complaints and not from their self-starting activities. Similarly, with the Public Protector, who has the power to take binding remedial measures, those won't happen if the public feels constrained by the lack of free speech in South Africa, which is why Section 16 of the Bill of Rights exists, so that a free flow of information is possible. We do need to note at this juncture that our Chapter 9 institutions have become sites of cadre deployment, and certainly the Office of the Public Protector has been captured by those loyal to Jacob Zuma, and that has had a deleterious effect on the effectiveness of Chapter 9 institutions. When accountability now started, we wrote to the Independent Electoral Commission and said to them, how can you say that there are fair elections in South Africa when only the ANC and its alliance partners are able to raise party political funding by going into partnership with government or by taking commissions on the arms deal and such like? And the answer that came back was, go and speak to Parliament about that. They weren't prepared to get involved in the ensuring of free and fair elections because it was too much of a political hot potato, and because their allegiance to the National Democratic Revolution rather than to the Constitution itself rather tripped up their proper functioning. However, since the Zondo Commission, there are recommendations that cadre deployment in the public administration, which would include the Chapter 9 institutions, should be brought to an end, and there is litigation pending at the moment in which the Democratic Alliance is seeking to achieve just that end via the courts.
Thank you, Paul. And you touch on the symbiotic relationship between Chapter 9 institutions and whistleblowers. So, Cynthia, I'm going to go back to you, not looking only at Chapter 9 institutions, and also noting the massive challenge that you state in whistleblowers coming forward, exercising their free speech rights, and in some cases, paying for their bravery with their lives. How should government be creating a safer climate for whistleblowers to come forward?
Thanks very much, Tyla. How should governments come forward? So firstly, there's legislation currently in place for protection of whistleblowers, and quite a list of legislation. So we have the Constitution, if I may start with that, in certain sections, which has the freedom of speech, which has everyone has dignity, the right to dignity, and the right human rights sections. There's section 15 and 16, I think, of the Constitution that talks to the rights of whistleblowers. And then we have the Companies Act, which specifically states that and refers to the Protected Disclosures Act, which is a separate act, and the protection of whistleblowers. So it means board members, executive members of the Companies Act or any organization should be protecting whistleblowers. And then there's the Protected Disclosures Act itself, which right up front states that no whistleblower should suffer occupational detriment. It states that they have the recourse to other courts should there be victimization to them in the course of seeking justice. However, the legislation is there, but what transpires is how it is enforced. And we've seen from a whistleblower perspective is that the Protected Disclosures Act, which was enacted in 2000 and later amended in 2017, even then has not been worthwhile for the whistleblowers. It has had no benefits for the whistleblowers. Out of cases that have gone forward in the court, I think 3 areas whistleblowers have won their case, but when they came back to the organization, they were still sidelined and therefore eventually left the organization. So the victimization there for whistleblowers is really strong. What we would like to see now in the legislation, that it is improved and that there's a link made between the various legislation that is in place, like the PRECA Act, which is against corruption, where people should speak out, like the Companies Act and obviously the Protected Disclosures Act, that the links are made and pronounced and highlighted so that it does not give the person, the perpetrator, the right and the freedom now to go ahead and victimize the whistleblowers. If those laws can be tightened and raised to a higher level of recognition, I think that would help. The current PDA that we have, the Protected Disclosures Act, definitely still needs further enhancement in the mere fact that the perpetrators who are called out and complicit in fraud, there is no sanctions against them recommended in the Protected Disclosures Act. And for the whistleblower to raise it, it's ignored. And so therefore that area needs to be enhanced. And that's the reason why most of the perpetrators and people complicit, or organizations complicit in fraud and anti-corruption, have got away, because they know this. And that area is definitely needs to be then enhanced. Thank you.
Thank you, Cynthia. And you make a very pertinent point about it's not only about the legislation, it's not only about the mechanisms, but it's how it's enforced. So, Paul, I'm going to speak to you now about what came out earlier this week, where Parliament's Justice Portfolio Committee heard that only 3% of the public protector's remedial actions have been fully implemented by state organs in the 2 years between April 2021 and March of this year. What impact does this have on holding accountable those public officials who are named in such reports after whistleblowers come forward, exercising their free speech right and putting their lives on the line?
Yes, I'm afraid that those are shocking statistics. It may be a reflection on dysfunction in the Office of the Public Protector, but it is certainly something that requires the attention of the legislature. So if public servants are simply tearing up or ignoring the findings of the Public Protector, then the efficacy of that office is completely undermined, and the work and the blood and the sweat and the tears of the whistleblowers goes to waste as a consequence of it. It may also be that too many of the reports that have been finalized under the current Public Protector are not of the quality that would survive a review, and far too many of the reports have in fact already been reviewed. So there's a sort of standoff between the Public Protector and the government agency or Department of State that is the subject of an adverse finding in a report, and the threat of a review prevents the Public Protector from actually being proactive about the enforcement. At this stage, it is already possible for the Public Protector to go to court and say, my remedial action is being ignored, and I want the court to order, so that contempt of court proceedings can follow for any miscreant who is ignoring an instruction or the remedial action of the Public Protector. But that is not done, mainly because of this cozy club of deployed cadres in the Chapter 9 institutions. And that can only be addressed if Parliament sees to it that those who are appointed to Chapter 9 institutions are indeed mindful of their independence and are prepared to act in a manner that complies or ticks the boxes of without fear, favor, or prejudice. Until that is done, we're in trouble. On the protection of whistleblowers, which Cynthia has touched on, I think that it's important to note that the Protected Disclosures Act is really focused in a labor law sort of way. So it's the relationship between employer and employee that has been regulated by that act, whereas disclosures where there is not a employer-employee relationship also deserve protection. And then on the whistleblower protection legislation, it is an unfortunate feature of that legislation that protection does not kick in until the prosecutor has identified the whistleblower as a necessary witness in the prosecution that is going to flow from the whistleblowing. And sometimes there's a very long gap, long time lag between the actual blowing of the whistle and the commencement of the criminal trial, the decision to regard the whistleblower as a witness. And in that period, the whistleblower is extremely vulnerable because the machinery of the Whistleblower Protection Act cannot be invoked to protect that whistleblower. So those are fairly simple amendments that could be brought about. And another way to protect the identity of whistleblowers would be to create an informal ombud organization made up of retired judges to whom whistleblowers could go in confidence and explain what their concerns are and be protected by the Ombud, who will use the machinery of state without actually identifying the whistleblower that has come to the Ombud. That is done successfully in parts of Germany. And we have a very useful resource, fully paid retired judges who are not that old and who could make their services available as an Ombud to whistleblowers, who would then protect them in that period between the actual whistleblower and becoming a star witness in a criminal trial.
Thanks for that, Paul. I want to now turn to the impact of politicking in Chapter 9 institutions, in whistleblowers. We've all watched government's response to former CEO of Eskom, Andre de Ruyter's allegations of mass corruption at Eskom, which has included attacking his character, labeling his claims as false, and the president outright refusing to investigate them further. Now, this hasn't silenced him, but it has pulled his reputability into question. How does similar political response impact the role of Chapter 9 bodies and whistleblowers who also face backlash for their work? Cynthia, I'm going to turn to you first.
Thank you for the question, Tyla. So in the case of Mr. de Ruyter, is that he has previously raised these issues. I recall attending a couple of forums prior when he gave talks and obviously reading it in the media. And for him now to have that presentation that he did earlier with ENCA and gave the information, it was really nothing new. He has also instigated investigations within his organization. He has the right to do as a CEO. The sense is here right now that it is easy for our government to rather, again, vilify a person who's speaking up for the truth, rather than to look and see what is going wrong, how do we fix it? They have not once made a suggestion of how to fix Eskom. Now it's all just retaliation. It's literally tearing his words apart. He said this, they said that type of issue, rather than trying to find the source of where the issues are. How do we fix it? Is there corruption? How do we fix it? If there's sabotage, how do we fix it? And for me, that is the playbook that our government has been enforcing in every way. So it's an avoidance type of attitude and a blame game rather than trying to solve the problem. I'd just like to bring up another issue that happened recently. So an MP, a recent MP, Minister of Parliament, Mr. Mosebenzi Tswana, was suspended, but with one full term only at Parliament for being complicit in giving approval for transactions like Optimum Mine, for instance, and Tegeta. Now, if you take it back to us, Eskom, that was key areas that affected Eskom at the time, and that was even before Mr. de Ruyter was there. Secondly, there were whistleblowers from Eskom at the time, and like Suzanne Williams, who had given testimony at Parliament, and people who had from other organizations like Trillion, who were part of the process, who received gains for not doing any work like Trillion. And so there were two whistleblowers from Trillion, Msilo Matepo and Bianca Goodson, who spoke out at that time about these type of transactions going down. And again, Parliament turned a blind eye. There was no further investigation. These two whistleblowers were victimized and vilified. And in her own words, Msilo Matepo was saying that she became a person that no one wanted to even employ or give a job, the same as Bianca Goodson. And so I just wanted to bring those two contexts where there is a actual parliamentary person involved in it. What is his punishment, as I may say? So he gets one full term. There's no monetary sanction against him. He doesn't lose his position as an MP, and he has everything still in place. Where those lost their jobs, the only way they managed to retain their homes was through an outside organization stepping in to keep their homes. It was through an outside organization like PLAF assisting them by giving them a stipend to continue monthly and by providing the legal support. Whereas Mr. Tshwane, nothing has happened to him. So just to bring that comparison to you and highlight it. Thank you.
Thank you, Cynthia. Paul, I'm going to ask the same of you in terms of the impact of politicking on the work of Chapter 9 institutions. And specifically, I want to bring it to suspended public protector Busisiwe Mkhwebane's assertion that she's similarly been vilified to avoid accountability. How do you respond to that?
Yes, I'm afraid that in the case of Zwane, he is in fact an accused in a criminal trial, but the wheels of justice are turning far too slowly. But to deal with your question, it is true that the ANC is feeling the pinch, mainly because in the process of state capture, as the president has correctly observed, the ANC is accused number one. And that means that a lot of the people in the ANC are sweating because the dreadful day of judgment in relation to the roles that have been played by them and their friends in state capture are now going to be interrogated by the Criminal Justice Administration, which is not moving at a pace that is satisfactory, but is at least attempting to hold the perpetrators of state capture to account. So the fact that the ANC has sued Mr. De Ruyter for blowing the whistle on the Annika Larsen program is simply a political posturing. It's not a serious attempt to suggest that he is making it up. He is not making it up. It is very clear that Eskom is the victim of a great deal of shenanigans and chicanery. The role of the Chapter 9 institutions in this, if they are not politicized, if they are not manned by deployed cadres of the National Democratic Revolution, is to be part of the solution rather than part of the problem. But it's very clear that Busisiwe Mkhwebane was deployed to Chapter 9 as an antidote to the good work that was done by Thuli Madonsela, her predecessor, and that she has been there protecting the RET faction of the ANC and promoting their cause as well to the best of her ability, which is not the job of somebody who is acting independently and without fear, favor, or prejudice. So I expect her to come second in the inquiry that is currently underway. But her term of office expires in October 2023. So we are not going to have to put up with her for much longer. And we must hope and pray that Parliament has enough good sense to appoint another Thuli Madonsela rather than another Busisiwe Mkhwebane to the position of public protector in South Africa.
Well, we'll certainly be watching how the inquiry unfolds and crossing fingers throughout. I just want to turn back to how we started this discussion, which was on the basis of free speech. Now, the hate speech bill has been improved markedly from the initial version presented to Parliament in 2018. That initial version included occupation and political affiliation as grounds on which hate speech could be based. However, the new bill still broadly defines harm to include social or economic detriment that objectively and severely undermines the human dignity of the targeted individual, and it also states that a victim can be a juristic person. What could this mean for civil society organizations who call out government institutions and the important work that you've both referred to of Chapter 9 institutions and whistleblowers? Cynthia.
Tyla. Yeah, I see this as having a detrimental effect and probably more devastating, that it then hampers the free speech and the ability to speak out against certain people's behavior or what is transpiring in certain situations. Case in point, we've seen that's happened is when if I can use from a political perspective, the Economic Freedom Front, when they speak out, they use some very harsh hate speech. And then when an ordinary citizen speaks out against their internal racism issues, there is different reaction to it. And for me, that is obviously not a fair assessment of the situation. If I look back at South Africa and my own upbringing, is that we all born into an environment where there are the internal biases that firstly from our parents, secondly from the environments we grew up in, and then thirdly into which we find in our either education or in our workplaces. And so we form these biases through our own experiences, and some, yes, are extreme, and so some can be just stated out of because you don't know any better and you didn't explore the other person's ideology. And so for me, I think that new hate bill that has come out does not allow for one to balance the person's own inner biases that they have and background that goes with it, versus just bringing it into straight black and white. So it would have devastating impact on those people. And I feel that, yes, that shouldn't really be allowed to go forward as it is in this current state. There needs to be some sort of balance, because there are those extremes, and when one puts the extremes in place, is it meant to hurt? Is it meant to defame? Is it meant to damage? And then have that sort of assessment. Thank you.
Thank you, Cynthia. And just on that, the foundation was recently in court due to a decision by the South African Human Rights Commission that comments made by Malema in 2016, where he called for the slaughtering of white people, but qualified it with "at least not for now," did not amount to hate speech. So we agree there is a need to decisively deal with hate speech. But as aptly put by Sarah Gahn, director of the Free Speech Union, sometimes the best way to deal with hate speech is free speech, is to debate it, is to say that's not going to fly in the society under this constitutional dispensation. Paul, how do you respond to what Cynthia has said? And how could a bill that broadly defines harm to include social and economic detriment, and that allows victims to be a juristic person, impact the work of a Chapter 9 institution?
In my view, the broadness of the bill renders it unconstitutional. What it is seeking to do is to limit the right to free speech, to prevent people from uttering hateful speech as defined in the bill in ways that are very difficult to pin down. Now, it is possible to limit the right to free speech. The Section 16 itself limits the right to free speech. But if further limitations on the right to free speech are to be brought onto the statute book, then they have to be done in a way that is reasonable and justifiable in an open and democratic society such as ours. And my water tells me that the Constitutional Court will take a dim view of the attempt to micromanage freedom of speech by creating categories of hate speech that are punishable by law. So I would not see the work of the Chapter 9 institutions being advanced or strengthened in any way if the hate speech bill does become law. It will be harder to fulfill the mandates of all of the Chapter 9 institutions if hate speech is limited to the extent that the bill contemplates.
Well, thank you, Paul and Cynthia. That is all the time we have for today. And thank you to our audience for joining us for the episode of This Constitution at Work. Remember to like, subscribe, and turn on post notifications to be alerted when our next video is up. If you have feedback on today's episode, please feel free to have your say in the comments section. You can also follow us on Facebook, Instagram, LinkedIn, and Twitter at FW de Klerk Foundation to keep up with our latest news. We look forward to checking in again soon.